Hello viewers, Attorney Buado here. Welcome to the Criminal Law Jurist. This is Episode 6, Philosophies Underlying the Criminal Justice System. There are 4 philosophies: classical or juristic, positivist or realistic, eclectic, and utilitarian theories. The classical or juristic school is mainly followed by the revised penal code. Its predominant characteristic is the identity of mens rea, which means guilty mind, or wrongful purpose, or criminal intent. When one commits a crime, it is presumed to be voluntary or with freedom, intelligence, and intent. This school believes that punishment deters the commission of crime. So what are the characteristics of this philosophy? First, its basis for criminal liability is the idea that a person is essentially a moral creature with an absolute free will to choose between good and evil. Therefore, he deserves to be punished, so he will not repeat the crime, and others will be deterred because of the severe punishment. The purpose of the penalty is retribution, to serve the right of the state and of the victim. How is the penalty determined? It is already fixed and established by law in direct proportion to the gravity of the crime. For example, homicide carries a maximum imprisonment of 20 years, whereas murder a maximum of 40 years imprisonment. The emphasis of the law is on the offense. The graver it is, the more severe the penalty. The positivist or realistic school modifies the harshness of the classical or juristic. It considers the sum total of the social phenomena to which the offender is exposed. And so Congress enacted laws following this theory, like the indeterminate sentence law and the probation law. The state is concerned not only in protecting society from crime, but also to redeem the convict for economic usefulness and other social ends. What are the characteristics of this philosophy? Its basis is the theory that man is inherently good, but because of his environment and upbringing, he becomes socially sick. The purpose of the law is corrective, to reform the offender. Thus, prisons are also called reformatory or correctional institutions. How is the penalty determined? On individual basis, after considering the circumstances like age, relationship with family and community, exposure to environment, economic status, etc. Its emphasis is on the actor. Third is eclectic or mixed, which combines the features of the classical and positivist philosophies. Lastly, the utilitarian or protective theory believes that the function of punishment is to protect society from potential and actual wrongdoers. The retributive aspect of penal laws should be directed against them. The law should not be applied to further materialism and opportunism. Are there actual cases applying these philosophies? There are. The classical theory is exemplified by the case of Echegaray, who was executed because his crime is incestuous rape of his own daughter. It is a capital offense, so it carries the extreme penalty of death. How about the Positivist? Lim versus People. The Supreme Court applied Administrative Circular Number 12/2000 that establishes a rule of preference in the application of penal provisions of BP22, where the offender and the offense clearly indicate good faith or clear mistake of fact without taint of negligence. Fine is the better penalty than imprisonment. For issuers of bouncing checks are usually businessmen who are helpful in our economy, but sometimes business reversals cause the checks to become unfunded. The Utilitarian Theory, on the other hand, is exemplified by Magno versus Court of Appeals. Magno issued 4 collateral checks for his loan accommodation. Therefore, he should not be punished for mere issuance of the checks in question, especially because he returned the machineries loaned for which the collateral checks were issued. Since he has returned it, the lender has no right anymore to deposit the checks, but still she deposited them, showing that she is the actual and potential wrongdoer, who should not be glorified by convicting Magno. Clearly, the application of these philosophies affect the defense or prosecution of accused, the penalty imposed, and whether they should be convicted, acquitted, jailed, or just fined. So there you have it, the philosophies underlying the criminal justice system of the Philippines.